Hello everyone, good afternoon, and thank you so much for joining us for this conversation about reproductive rights and justice in a post-Dobbs world. My name is Casey Danoff, and I use she, her pronouns, and I'll be your moderator for today. And I am a Penn Catalyst Legal Fellow at the ACLU of Delaware. I earned my JD from the University of Pennsylvania Carey Law School in 2023, and I also have a graduate certificate in gender, sexuality, and women's studies. As a young woman at the start of my legal career, the fight for reproductive autonomy is always front of mind, so I am thrilled that you're using your lunch hour to join me in this important panel discussion. We're excited to announce that just last month, the Delaware General Assembly passed House Substitute 2 for House Bill 110, and this legislation ensures that people on Medicaid, private, and state insurance plans can access abortion without financial burden. Thank you to everyone who contacted their legislators in support of this bill. We're very excited to be celebrating this victory. However, much of the country is not so fortunate, and on that note, we'll get started with introductions and get into the discussion. From the landmark moment when the Supreme Court recognized the right to abortion in the 1973 case Roe v. Wade, anti-abortion advocates got to work to begin chipping away at that right. And fast forward to June 2022, I think we can likely all remember where we were when we learned that the Supreme Court had taken their final wrecking ball to the last remains of the right to reproductive autonomy in the case Dobbs versus Jackson Women's Health Organization, the case that overturned Roe v. Wade. Unfortunately, beyond the immediate shockwaves and harms from that overturn, of which there are many, there is certainly more to come. Just this term, the Supreme Court heard 2 more cases in the realm of reproductive autonomy, and countless other challenges have sprung up around the country to further threaten access to care. And we're now left with a patchwork of varying laws and restrictions that limit access to reproductive health care that is nearly as confusing as it is dangerous. But today we are joined by 2 exceptional panelists and personal mentors of mine who are graciously sharing their expertise with us. Ming Chu is the Deputy Director of the Women's Rights Project at ACLU National. The Women's Rights Project engages in systemic legal reform to ensure that everyone has the freedom to live, work, and learn, free from stereotypes, harassment, and violence based on sex. Before joining the ACLU, Ming served in the Biden administration as senior counsel to the Solicitor of Labor, where she advised on a range of executive priorities, including the implementation of the racial equity and gender equity executive orders and the issuance of an emergency temporary standard to protect the health and safety of workers during the coronavirus pandemic. Prior to her work in the federal government, Ming was chief of the Civil Enforcement Section in the Labor Bureau of the New York Attorney General's office. Ming was additionally part of the New York Attorney General's litigation team challenging federal administrative action during the Trump administration. Ming has also worked in private practice at labor and employment firm Vladeck, Raskin & Clark, PC, and as a lecturer in law at Columbia Law School. She is a graduate of Columbia Law School and Yale College. Yay. Serena Mayeri is the Arlen M. Adams Professor of Constitutional Law and Professor of History at the University of Pennsylvania Carey Law School, where she teaches and writes about legal history, equality, work, reproduction, and the family. She has also contributed to amicus briefs in cases involving these issues. Her first book, Reasoning from Race, Feminism, Law, and the Civil Rights Revolution from Harvard University Press, received the Littleton Griswold Prize from the American Historical Association and the Darlene Clark Hine Award from the Organization of American Historians. Her second book, Marital Privilege, Marriage Inequality, and the Transformation of American Law, is forthcoming from the Yale University Press. Mayeri holds a secondary appointment in the Department of History at Penn, where she is also on the executive board of the Program on Gender, Sexuality, and Women's Studies, and serves on the executive committee of the Andrea Mitchell Center for the Study of Democracy. Prior to coming to Penn, she earned her JD and PhD in history from Yale, clerked for the Honorable Guido Calabresi on the U.S. Court of Appeals for the Second Circuit, and served as a Samuel I. Golub Fellow at the New York University School of Law. Our conversation today will start by taking a deep dive into the Dobbs decision itself. We'll then discuss how Dobbs affects so many Americans daily in the realm of workplace justice and pregnancy. And finally, we'll reflect on the most recent Supreme Court term and think about how we can keep up this critical fight looking ahead. Please, please, please leave any questions you have in the question and answer, any comments, in the chat, and hopefully we'll have some time to get to them at the end, but we're starting a little late, so we'll see how it goes, but definitely leave those and hopefully we'll get to address them. But you've heard more than enough from me, so without further ado, let's get into it. When the Dobbs decision was leaked and then subsequently released, the country pretty quickly grasped that Roe versus Wade had been overturned and that the landscape of abortion access would drastically change. But Dobbs is a very long opinion. So my question is, how did Justice Alito reach his conclusion? What sort of reasoning does he use? And what is the full reach of what Dobbs does and also does not do? And Serena, I guess we'll kick it off with you.
Well, first of all, thank you so much for including me in this distinguished panel and conversation. Really honored and happy to be here. I'm charged with describing Justice Alito's reasoning in Dobbs, and I'll try to do so as briefly and concisely as possible. So I think we probably are all familiar with the ultimate holding that Casey just stated, that the majority overruled Roe versus Wade and Planned Parenthood versus Casey, which was the governing legal standard prior to Dobbs. The court said that those decisions were egregiously wrong from the start. They said that abortion is not a fundamental right because there's no history and tradition of protecting abortion. And this was really a departure from how the court had thought about history and tradition in the recent past. In cases like Obergefell versus Hodges, which had legalized same-sex marriage, the court had taken a very different approach to history, where the majority thought about how social mores and social movements even had changed the meaning of constitutional guarantees over time. Here, by contrast, the majority cited ancient authorities like Sir Matthew Hale and William Blackstone, and counted the states that banned abortion in 1868 as a measure of what Americans' constitutional rights would be today. The majority also said that the reasons for following past precedents, for adhering to the doctrine of stare decisis, which says you should follow previous case law, that the reasons for adhering to stare decisis didn't apply here. Planned Parenthood versus Casey had said that Americans generally and women in particular had relied on the ability to determine their reproductive destinies. But the majority in Dobbs says that's not the kind of reliance interest that's constitutionally protected. And Justice Alito went on to say that advances in women's rights, the availability of alternatives to abortion, and women's electoral and political power made abortion unnecessary to women's equality. Now, the majority claimed that its holding didn't reach other precedents that were decided under the same substantive due process doctrine as Roe and Casey. So precedents like Griswold versus Connecticut, Eisenstadt versus Baird, Loving versus Virginia, Lawrence versus Texas. These were cases upholding rights to contraception, to interracial marriage, to same-sex intimacy. All of those cases rested on the same analysis, but the court says those were different. We're not questioning those precedents because abortion is different. It extinguishes potential life, and that's not at stake in these other cases. Justice Thomas offered a quite different perspective in his concurrence. He really embraced the idea that all of substantive due process precedent should be reconsidered and called into question. So there was a disagreement on the court about what the ramifications might be for other areas of law. Another thing that the majority opinion did was it rejected an argument that the Equal Protection Clause might be an alternative basis for abortion rights. And I can say a bit more about that later, but for now I'll just say this was dicta in the opinion, but the dicta sort of purported to revive a 1974 case, Geduldig versus Aiello, which had said that discrimination based on pregnancy is not always sex discrimination. We had argued in an amicus brief, Reva Siegel, Melissa Murray, and I, with wonderful research help from Casey Danoff, that Geduldig had been superseded by almost a half century of constitutional law. And so the court sort of quickly rejects that and moves on. In their dissent, Justices Sotomayor, Kagan, and Breyer, of course, take a very different perspective, both on the methodology that should be applied to interpreting the Constitution and on the ultimate outcome. They emphasize the equality ramifications of the decision. They wrote that respecting a woman as an autonomous being and granting her full equality meant giving her substantial choice over the most personal and consequential life decisions. And they emphasized how the decision would subject women to coercion, to criminalization. And significantly, they really stressed the fact that women without financial resources would suffer the most from the court's decision. They echoed the many amicus briefs that pointed out how states that ban abortion also are the states that offer the stingiest supports to people who are pregnant and raising families, and have some of the highest rates of maternal and infant mortality in the country. The dissenters also, in rejecting the majority's approach to history and tradition, refuted the idea that there isn't any connection between abortion and other rights to bodily autonomy, sexual and familial relations, and procreation. They emphasize that all of these rights are very interwoven in the court's jurisprudence and in sort of just logically speaking, and that all are now in jeopardy. And the dissent closed, I think, with quite prescient and appropriate cautionary words about the effect of the majority's disregard for stare decisis, and the suffering that would result from its decision, the detrimental impacts of that on the rule of law and on the court's legitimacy. So that's sort of just a brief, I hope not too long, summary of what the opinion held. I just want to talk very briefly about the various legal and constitutional questions that Dobbs raised. And we've seen these really starting to play out, but I'm just going to pose them now as questions that the decision kind of left open. So one set of questions has to do with how the various approaches that states would inevitably take after Dobbs and have taken after Dobbs would be reconciled with one another. So can states, for example, enact and enforce civil and criminal penalties for residents of states that have abortion bans, who seek abortion in states where they're legal? More generally, can states enforce bans on abortion that don't make exceptions for rape, incest, the life of the pregnant person? Can states prioritize the life of an embryo or a fetus over the life of a living pregnant person? Can the federal government preempt state abortion laws, either to ban abortion nationwide if Congress were to pass such a law, or to protect reproductive rights everywhere if Congress were to, as has also been proposed, restore at least the status quo pre-Dobbs, or something broader to protect abortion rights? It also left open questions about how far states can go in criminalizing healthcare providers, in criminalizing pregnant people themselves. And it left open questions about whether states can now ban other forms of reproductive health care. Can they ban the mailing of abortion medications, aiding and abetting abortions in other states? I could go on, but I think that probably gives us enough to start with.
Thank you. That's very, very helpful background for this discussion. Ming, do you want to jump in?
Of course. And again, I want to say that I'm thrilled to be here echoing Professor Mayer's remarks here with you all and with her to learn from her, and especially with you, Casey. You were with me in the Women's Rights Project the day that the Dobbs decision came down, and helped me with a lot of the research in our post-Dobbs work. So thank you so much for having me. That is a terrifying list of open questions that you've left us with, Professor Mayer, but the theme for me today, I think, is not to overstate what Dobbs does, which, is hard to do because it was such a sea change, but I think we have to remember to not let Dobbs have a chilling effect on other abortion-related rights, because that is also an intended effect of the rights legal strategy, is to make people who get abortions or seek abortions feel like they have no protections at all. And that's not the case. And that's something that we have to push back on. So Dobbs, as Professor Mayeri says, decides whether there is a fundamental right to an abortion and what kind of scrutiny that states will get from courts when they pass regulations on the medical procedure of getting an abortion. But it doesn't mean that people who get abortions don't have other federally protected rights. So it doesn't mean that your employer can fire you if you get an abortion. It doesn't mean that your landlord can evict you if you get an abortion. It doesn't mean that your school can kick you out because you get an abortion. It doesn't mean that a medical provider can refuse to treat you because you've gotten an abortion. And so there are federal civil rights and other statutes that still do protect people who are seeking or considering abortion care, even though access to that care has been dramatically limited. And not surprisingly, the right is really trying to push back on these rights as well. But these are not questions that Dobbs itself decides. I will just say one wonkier point, and perhaps cold comfort, just to add to what Professor Mayeri said. The court says that now states' regulation of abortion is subject to what we know as rational basis review. So it's a very low standard. Basically, all regulations have to have a rational basis. They can't be arbitrary and capricious. So it is undisputably a low standard, but it is still a standard that states will have to meet. So a restriction that is motivated solely by animus toward pregnancy or toward women, which would not put it beyond states to have that in a legislative record, or solely for the justification of saving money because abortion is too expensive to provide in the state. Things like that, if that is the state's justification for abortion restrictions, still could fail even this lesser standard. So there may still be some ways in which the Constitution limits what a state government can do in regulating abortion, even if there is no longer a fundamental right to abortion.
Thank you. Yeah, that's a really important point to cabin what the explosive effect seems to be, at least where we can. And also just a reminder to everyone, if you have any questions about anything at all, please drop them in the question and answer or in the chat box. Moving on, in the practical terms of how the decision has been manifesting, how did Dobbs change the landscape of reproductive rights and justice across the country, and what have we seen happening in state courts and in legislatures? Serena, I think we'll also pass this one to you.
Great, thank you. And I think that I want to just echo, those are really important points about the need to not assume too much about what Dobbs does, to the extent that that indeed is part of what the anti-abortion movement is wanting us to do, is to chill a lot of conduct that might in fact be legal, or to dissuade people from having abortions because they might be afraid of the consequences. So I'm going to go back to the bad news. I'm sorry. But then I promise there'll be some good news at the end of it. So I think the bad news is that many of the worst predictions about the aftermath of Dobbs have indeed come true. I think we've all seen the devastating consequences for reproductive health care generally, and a lot of human suffering that has resulted from much of which is invisible, but some of which has come to the fore in the last 2 years. So we've seen things like people's inability to access prenatal care, care for miscarriages, including emergency medical care, for hemorrhaging, for missed miscarriages, for preterm labor, for all the things that can and unfortunately often do go wrong in pregnancies. A fairly large percentage of pregnancies end in their early weeks, and And we've seen what happens when people go to hospitals and emergency rooms, even with, situations where there's no possibility that the pregnancy is going to survive, and even in situations where those pregnancies are very much wanted, that they've been forced to wait until they're on the brink of death in order to receive care, including state laws that seem to ban the termination of pregnancies to avoid serious organ damage and other severe health consequences short of death. Doctors, and this is also part of the design of these laws, don't know how close to death a person has to be before they can act, and that has had very stark consequences. People have been forced to carry pregnancies to term and endure the anguish of a stillbirth or a baby's very short life of suffering because they're unable to obtain abortions, even when the pregnancy is not viable. We've also seen, unfortunately, a lot of predictable collateral consequences for people seeking reproductive health care, including but not limited to abortion, in states where abortion remains legal. So when it turns out there hasn't been a downturn in the number of abortions overall in the United States. Part of that is because people are traveling to states where it is legal, and that overloads the healthcare systems in those states. Many people, of course, don't have the means to travel out of state to obtain care, even when it is legal. And indeed, some statistics I was looking at this morning suggest that as many as 6 out of 10 Black and Indigenous people of reproductive age live in states with pretty severe bans. Another thing I just wanted to mention is we've also seen, again, a predicted but disheartening impact on the ability of doctors to get the training they need, not only just to provide abortions, but simply to provide emergency miscarriage care, which looks just like abortion. It's all the same set of procedures and medications and treatments. So what have I want to just put a little bit of some numbers to these generalizations. What have we seen in various states? And I think, sort of the broad picture is that what we've seen is really a divergence and kind of a polarization, also fairly predictable, with some states expanding reproductive rights and others severely contracting them. So I'm going to start with the bad news, and so I can end on a more positive note. So about 14 states have passed laws or had trigger laws that went into effect after Dobbs that have resulted in either total bans or near total bans. Some of these have been challenged in state courts with varying degrees of success. In several states, they've been upheld. I think about 3 states have 6-week bans, and then several more have gestational limits of 12 to 15 weeks. Several more have later limits than that. A small handful of states don't have a gestational limit at this point. While all 20 states that have abortion bans or early gestational limits do have exceptions for when the pregnant person's life is in danger, at least in theory. We've seen how poorly that works in practice. 6 states don't have any explicit exceptions for when a person's health is at risk, even at severe risk. 10 states have no exceptions for rape and incest. 13 states have no exceptions for cases in which the fetus has a fatal anomaly. That means that the pregnancy won't survive. In many states, litigation over these bans is ongoing, and in a few of those states, the bans are blocked in the interim. In many more of those states, the bans are in effect as they're being challenged. We're also seeing increasing numbers of laws that reflect a vision of fetal personhood, the idea that embryos and fetuses have constitutional rights commensurate with those of living, born human beings. And I can say more about that, but that's sort of the next frontier for the anti-abortion movement, and we've seen that play out in various ways. So I said I would talk about positive developments, and then I'll stop. So very quickly, several states have passed laws or enacted through ballot initiatives constitutional amendments to their state constitutions that enshrine reproductive rights in various ways, sometimes in very expansive and exciting ways. And I think state law is a really promising frontier in these ways. Several states have passed shield laws to protect healthcare providers from liability imposed by other states. And that's very significant, particularly because as of the end of last year, about 1 in 5 abortions are being provided via telehealth. A large percentage of abortions are medication abortions, not necessarily provided by telehealth. And then finally, I just wanted to say very quickly, public opinion on abortion has also shifted, and I think that's an important point to make. It turns out that these abortion bans, which were passed often by Republican lawmakers and other lawmakers, not just Republicans, but by lawmakers who thought that they could get away with passing an extreme ban because Roe and Casey were in effect and they didn't have to live with the political consequences of their actions. It turns out, not surprisingly, that these extreme abortion bans are extremely unpopular nationally and even pretty unpopular among Republicans in red states. And there's some evidence that as we've seen the horror of what it means to ban abortion, even when life and health are threatened, public opinion has shifted. So some surveys suggest that when you reframe the question, instead of asking something like, do you support abortion restrictions after viability or after the first trimester, et cetera, you get one set of answers. But it turns out that if you ask whether people think the government should be involved in decisions about people's pregnancies, upwards of 70 or 80% of respondents just say no, they don't want the government involved. So that's a very different picture, I think, than we're used to seeing of how Americans actually think about these questions.
Thank you. Ming, a question for you. Beyond reproductive rights, what other threats and protections lie within the Dobbs decision that we should be aware of?
Thank you. And I will just add that one other potentially positive development. I feel bad that Professor Mary is like the doomsayer, and I'm the one that swoops in with the positive notes. But I think that under a lot of these new state, both statutory and constitutional protections, advocates are able to lay a framework for a new kind of constitutional analysis that really departs from the federal jurisprudence. So, there is not a lot of independent sort of state specific constitutional analysis, and now this is really pushing state courts to engage with these questions and opens up a lot of new opportunities, which we'll talk about a little bit later. But yeah, Professor Mary already laid out some of the threats that were that the Thomas concurrence alludes to, which really lays out a roadmap of what may be up next, and on the chipping away of what we think of fundamental rights under the Constitution. I will focus on Justice Alito's discussion of sex discrimination and to the citation, as Professor Mary alluded to, of a case called Geduldig and what it means more generally for pregnancy and beyond. So I think just understanding that abortion rights are really inextricably linked to pregnancy rights, and it's being treated this way in the court's analysis. So just talk very briefly about what Geduldig is about. Geduldig was a case that involved a challenge to a state insurance program for employees that excluded coverage for pregnancy, and the court found there that the program was sex neutral because some women didn't get pregnant. So in other words, an exclusion in the program that doesn't affect all women can't be discriminatory. So the court says there that a medical procedure that regulation of a medical procedure that only one sex can undergo doesn't trigger heightened scrutiny under the Constitution. So this reasoning, again, as Professor Mary said, has been rejected in many ways in the time since. It was explicitly rejected by Congress in 1978 when they amended Title VII of the Civil Rights Act to specifically state that pregnancy discrimination falls within the definition of sex discrimination, and disavowed the reasoning in Geduldig and the cases that relied on it. More recently, it was also rejected in the underlying reasoning in Bostock, which is the Supreme Court case that held that discrimination on the basis of sexual orientation and gender identity is discrimination on the basis of sex. So this idea that you had to fall to fall within the definition of sex discrimination, you don't have to show that every person in a protected group is affected. So for example, discrimination against gay and trans men is sex discrimination, even if all men, or even if many or most men are not affected, even if all men aren't affected. But what the citation to Geduldig in Dobbs suggests is that this principle may be in question, or it really emboldens the right to call this principle in question. And we've already seen the right really seize on this argument in the case of LW versus Grimetti. This is the challenge to the Tennessee ban on gender affirming care, where Tennessee repeatedly cites Geduldig for the proposition that regulating a medical procedure that only trans people undergo is sex neutral. So this is Geduldig. And so the implications of this foreboding discussion are not just for abortion, they're for pregnancy and more generally other sex-linked characteristics like gender identity and sexual orientation.
So staying a minute on this topic of the close link to pregnancy discrimination, I'm wondering if you could talk a little bit about what some common obstacles are that pregnant and parenting workers face and how Dobbs has impacted those obstacles or existing obstacles or new ones.
Yeah, and this returns to what we were discussing earlier, which is that we see red states trying to use Dobbs to challenge the idea that there are still existing federal statutory protections for people who are seeking abortion care. And they want to convince courts that Dobbs simply wipes away all of these rights and that there are now no bounds for states or private actors to harass or fire people who get abortions. So I'll start with the challenge to the regulations implementing the Pregnant Workers Fairness Act. This is a groundbreaking statute that passed in 2022. It went into effect last year, and in April, the EEOC issued regulations explaining what the law's protections mean. So the statute requires employers to provide accommodations for pregnancy-related medical conditions, and that includes abortion care. And that is really important because obviously, because of the bans, it's taking an increasingly long time for people to get the abortion care that they need because they have to travel out of state. And even where states where it is legal, people are facing increasingly lengthy wait times to get abortion care. And it's also important because access to leave from work is very limited. So the FMLA, the Family and Medical Leave Act, is only available to about half of the workers in this country. And paid leave is even less accessible, especially for people who are in low-wage industries. And there's obviously no federal law mandating paid leave. The Americans with Disabilities Act, under that statute, it is fairly established that you can get leave as a form of accommodation, but not all pregnancy-related conditions qualify as a disability under the ADA. So given this patchwork, it's really important that people understand the protections under the Pregnant Workers Fairness Act, which employers are already violating left and right, because that could be the difference between whether someone is able to get time off from work and access the abortion care they need. And so since the PWFA went into effect, we've already seen horror stories. In one case, we've heard from a worker who was in a position as a sales rep in Missouri. Her water broke when she was 18 weeks pregnant. Doctors at the hospital said that her fetus couldn't survive, and that she would if she didn't get an abortion, she would risk serious infection, hemorrhage, and the loss of her uterus. But that hospital refused to treat her. Well, the worker then traveled to Kansas to another hospital that refused to treat her. Then she had to drive to Illinois while she was in labor. And then all during this time, she was getting messages from her employer saying that she would be disciplined and likely fired because she had to take time off to travel. She eventually, when she came back, even though her doctors advised a much longer recovery period, she had to go right back to work because she didn't have any more time off, and she was ultimately disciplined for taking that time off for work. And another abortion provider in Illinois repeats very similar stories that people who are advised to take time off, even to recover from miscarriage or abortion care, just can't do it because their employers are saying you have to come back to work. This is an unexcused absence. And by the way, even since the pandemic, we have seen employers adopt increasingly draconian attendance policies, which penalize workers for every second missed of work. And so this is why the regulations are so important. And these regulations, of course, were immediately challenged. I will mention, but by a group of red states and the United States Conference of Catholic Bishops. I will mention that there's also a parallel set of challenges to the Department of Education's regulations under Title IX, which is the statute that protects students against sex discrimination. And those regulations likewise make it clear that that Title IX protects students who seek abortion care as well. And that has been challenged in 10 lawsuits across the country. So far, these arguments of red states have been unsuccessful, but I think that we do not expect that these arguments will go away, and I think that we have to be prepared to respond to them and push back hard as questions that Dobbs doesn't address, because we see again and again their papers saying that Dobbs answers these questions about what rights people who seek abortions have.
Absolutely. And I think getting that full picture of what the law really is beyond Dobbs is so important for informing everybody on what their rights still look like. And on that point, I want to move us forward in our conversation, looking at the time, and make sure we spend a minute discussing the most recent Supreme Court term, which really packed a punch, especially right at the end. But there are at least 3 cases that significantly implicate reproductive rights and justice that I think would fully add to the picture here. So I guess we'll start with you, Serena. Would you be able to talk a bit about the EMTALA case and the mifepristone case and explain where they kind of leave us in this discussion?
Sure. So I'll try to be quick about it. I'll talk first about Alliance for Hippocratic Medicine versus FDA, informally known as the mifepristone case. In this case, a group of doctors and for some reason dentists challenged the FDA's approval of mifepristone based on false pseudoscience, really, about the alleged dangers of the drug, which in fact is safer than Tylenol. And in this case, as expected, the Supreme Court dismissed the case on standing grounds. In order to have standing to sue, you have to have an actual injury. The injury has to be caused by the defendant's action, and the injury has to be redressable by the court. You can't challenge a regulation based on a sort of far-fetched hypothetical or intangible harm. And the doctors made a variety of arguments about why they should have standing. I won't go into too much detail. They were all rejected by the court, and they were all pretty out there. Despite the fact that they were pretty out there, both the Federal District Court and the Fifth Circuit Court of Appeals had allowed the doctors to move forward with their case. I want to just note a few important things about this decision, which unfortunately was sometimes portrayed in the media as a victory, which it was to the extent that it preserved, for now, access to mifepristone, and that's very important and should not be understated by any means. At the same time, I think it's really, really important to recognize that this did not resolve the issue. It's not going away. It really merely kicks the can down the road until after the election. It also, like many of the cases that come up from the Fifth Circuit, kind of allows the court to look reasonable and moderate by comparison to that court's extremism. And the reason why this case is not going away is because, first of all, the anti-abortion movement can and will bring new challenges to the FDA's authority to authorize the use of mifepristone using plaintiffs who do have standing. And the opinion, I think disturbingly, the opinion from the Supreme Court gestures toward political roots for abortion opponents. It says you can take your concerns to the executive branch and the legislative branch. And we've seen, and I think this is getting delayed but overdue attention, some of the plans of the Heritage Foundation's Project 2025 and other plans in place for a second Trump administration. Project 2025, for one, details plans to restrict abortion and access to reproductive health care in a wide variety of ways, including enforcing the 1873 Comstock Act, which is essentially a backdoor way to enact a national abortion ban without having to go through Congress or be accountable to voters. The other thing I just want to say about this decision is that Justice Kavanaugh's opinion for the court seems to suggest that healthcare providers have very broad conscience-based exceptions, much broader than the court has recognized in the past. And the decision even implies that doctors and nurses and other providers can decline to participate in emergency or other healthcare based on the idea that to do so would be complicit in abortion. And that seems to open up a whole wide range of possibilities for conscience-based exceptions, even when someone is, shows up in an emergency room in a serious medical emergency. Speaking of emergency care, I'll just say a few words about Moyle versus the United States, which is the EMTALA case. EMTALA stands for Emergency Medical Treatment and Labor Act. And that statute requires that hospitals provide stabilizing care to patients who show up in an emergency room, regardless of their ability to pay. It was really designed to address the problem of ERs turning people away if they didn't have insurance. And after Dobbs, states that banned abortion insisted that they were no longer bound by EMTALA to provide abortion care when it was necessary to stabilize a patient. And in these states, this is where we saw some of the horrifying stories emerging of patients being airlifted out of states in the grip of life-threatening medical emergencies. And on the strength of some of these horrors, a lower court issued an injunction to force Idaho to comply with EMTALA. This previously was thought to be, I think, a very clear-cut question. There's a clause in the Constitution that says federal law is supreme over state law, and EMTALA clearly needs to be followed, even if state law conflicts when a patient experiences a health emergency that requires termination of a pregnancy. The court in Moyle split pretty significantly, even though the actual holding of the case was a dismissal of the case as improvidently granted. I won't go through all of the different positions that the justices took, but I just want to highlight what Justice Ketanji Brown Jackson said in her opinion, dissenting, concurring in the outcome of the case, but dissenting from the dismissal of the case. She says, this was a months-long catastrophe for patients in Idaho and elsewhere, occasioned by the court's premature intervention in the case, and that this is a clear-cut legal question under EMTALA and the Supremacy Clause. And by further delaying a ruling on the merits of the case, she said, the court left pregnant patients, not just in Idaho, but in Texas and other states where federal and state laws conflict, to continue to suffer from uncertainty about what the law requires or prohibits. So I think the moral of all this is to say the court kicked the can down the road in a way that may have made it look moderate, perhaps intentionally, before the election, but none of these questions are going away, and people are continuing to suffer from all of these laws and the uncertainty that they create.
And Ming, could you quickly tell us a bit about Loper-Bright and how administrative deference doctrine is also very relevant here?
Of course. So I'll just give the broad strokes of Loper-Bright without diving into administrative law. But Loper-Bright is basically a case that takes away power from regulatory agencies. So before, under something called the Chevron doctrine, an agency had discretion to interpret a statute as it saw was reasonable. And in many cases, a court, if the interpretation was reasonable, had to defer to the agency as expert. So what Loper-Bright does is it takes that deference away. So it overturns Chevron. And so, an example of how this would work is that, Department of Education. So the statute Title IX says sex discrimination is prohibited in schools, and then Department of Education interprets what that means and explains sex discrimination also covers pregnancy and abortion. So the Department of Education's interpretation would, under Loper-Bright, no longer be entitled to deference. That's the general principle. And advocates had really been relying, it's different because often advocates challenge agency action, but in this space, advocates have really been relying on regulatory agencies to clarify and enforce civil rights protections for people seeking abortions. So it's a really big deal if agencies no longer have this power. But in terms of the current challenges to the rules under the PWFA and Title IX that I just was talking about earlier, we expect the impact on these cases to be quite limited because in the most high-profile cases, the federal government has relied on Chevron on a very limited basis over the last few years, and that is the case here. Chevron is cited in one footnote in the whole Title IX regulation, and same with PWFA. And then in Title IX and in relevant to PWFA, the agencies, the EEOC, have for decades been interpreting sex discrimination to include pregnancy discrimination and abortion. And this is a specific situation where the Supreme Court said in Loper-Bright where an agency could still get deference. So if an agency's interpretation has been really consistent over time, and if they first interpret the statute shortly after it's passed, in that scenario, an agency still could get deference. And so that's the case with both Title IX and PWFA, which borrows the definition of sex discrimination from Title VII. But that's obviously it is not the case more broadly.
Thank you. And I realize that we're pushing time, but since we started a few minutes late, I would love to leave everyone with some sort of optimism or at least forward-looking set of actions. Maybe that's more appropriate before we all depart. So Ming, I'll kick it off with you. What can we do moving forward? How has strategy changed? What are advocates doing to start chipping away at some of this harm?
Yeah, I will try to do this quickly, but I'm thrilled to talk about our challenge to the Nevada state ban on coverage for abortion in its Medicaid program, particularly relevant to those in Delaware, given your new statutory developments. But we challenged the Medicaid abortion ban under the state's newly passed and very expansive Equal Rights Amendment, and got the court to rule that the Medicaid abortion ban was unconstitutional under the ERA. And we really dreamed big in our legal arguments and came up with actually a whole new standard for how sex discrimination claims under the state constitution should be evaluated. So I'm so sorry I have to talk about tiers of scrutiny in this last portion. But basically, under the Constitution, regulations that discriminate on the basis of sex are treated more leniently than race. So sex gets something called intermediate scrutiny, and race gets something called strict scrutiny. So it would be a win to just bump sex up to get the same treatment as race. But given our concerns about how the federal Supreme Court has applied strict scrutiny to race, namely using it to strike down remedial programs like affirmative action, we didn't want to replicate that analysis. And so we proposed a new standard, which is something called equality review, where a court evaluates both if a regulation discriminates on the basis of sex, but then looking at the way in which sex is treated differently within the context, able to evaluate the history and context of the classification or discrimination. So that would preserve something that was designed to be a remedial action, and strike down something that was entrenching inequality. The court unfortunately didn't reach this question of whether equality review could apply, but I think it is just an example of is a blank slate in some of these new constitutional amendments, and I would encourage advocates to really dream big.
That would be amazing. Hopefully they take it. And Serena, what final thoughts do you have for us about what we can either learn from the past or what we need to do moving forward?
Yeah, so first of all, I just want to echo, that's incredibly exciting development, and I think is also echoed across a number of other states. And I think states are, at least for the foreseeable future, really a place where that kind of progressive innovation can happen, and it is happening already. And that's really, I think, heartening to see, and something that can be carried forward, at least in the states where that's possible. I guess I would just end by saying, I think the other big front here is politics and elections and democracy. And I'm a historian, and so I studied 20th century social movements, and the conservative legal movement has been incredibly successful over a period of decades in really creating the conditions that led to Dobbs' overturn, and also creating the conditions for the rise of the right that we're seeing today. And I think we need an equally and hopefully more efficient, but equally robust effort to, not to put it too dramatically, but to save our democracy, and to make sure that we have the ability, the institutions, the electoral processes, the integrity of elections, the integrity of voting rights, so that we can preserve our ability to elect leaders who will follow what the majority of Americans want. I think it's very clear that the only way that the conservative legal movement can and has prevailed is to undermine those democratic institutions, because they cannot win on the merits. Majorities of Americans, not just in reproductive rights, but across a wide range of issues, are opposed to their agenda, and it's up to us to make sure that it doesn't happen.
Thank you. I think that is exactly the point to end on, and hopefully gives everyone some enthusiasm and energy moving forward. But I want to thank both Serena and Ming so much for being here. Your experience and expertise is so valuable, and it is such a pleasure to continue to learn from both of you. And I hope everyone has a wonderful rest of your day. Thank you so much for sticking around with us despite the technical difficulties, and stay cool. Thank you, everyone. Have a good one.
Thank
Bye.
you so much.